Welcome to hashtag IP series. If this is your first time joining us, thank you so much for listening to my podcast, which features conversations on recent cases and global trends. And for my returning listeners, you guys are the best. Thank you guys so much for always coming back to listen to my podcast. I remain your host, Rita Chinda. Please favorite my podcast on Anchor, Google Podcasts, Breaker, Radio Public, Overcast, Listen Note. And I'm excited to talk to you guys about today's topic. I hope you guys are as excited as I am when I was recording this. But let's get right into it. Hi and welcome to hashtag IP series with Rita Chinda. If you're a first time listener, thank you so much for listening to my podcast. If you're a returning listener, you guys are the best. Thank you for always coming back to listen to my podcast, which features conversations on recent cases and trends globally. Please don't forget to subscribe to my podcast on Anchor, Google, Spotify, Breaker, Radio Public, Overcast, and Listen Notes. Please also support my podcast so you can keep seeing future episodes on any of the platforms I mentioned. So today's topic is a rather interesting one, especially for SMEs. And this year, the World Intellectual Property Organization celebrated the World IP Day with the theme IP and SMEs before taking your ideas to the market. And so this case is very important. It makes emphasis on IP due diligence that SMEs need to pay attention to going forward. Let's get into our case study for today. So, today's case study is one of those cases where, as an SME, if you don't do your IP due diligence, you might be called out, especially in this era of social media, calling out. You might be accused of infringements and the rest of it. And this is a fight between two giants, one in the tech space and one in the fashion and makeup industry. And these two giants are fighting about their logo, and I'll be telling you what this logo basically looks like. So this is a case between Chanel and Huawei on the similarities of their brand logo. So they are fighting about the interlocked double C, which Chanel is popularly known for. And in this case, it's Chanel that is accusing Huawei and the tech brand for infringing on their logo. So our topic for today is likelihood of confusion, how likelihood of confusion is determined, and what SMEs and entrepreneurs need to know before taking their ideas to the market. I hope you guys learn something. Please favorite my podcast. So, as tradition, I'm going to tell you a summary about the case. So sometime in 2017, Huawei, the Chinese tech giant, applied to trademark their logo in the European Union to be used for computer hardware, and it was opposed by Chanel, the fashion label, stating that the two vertical intertwining semicircle were similar to their own interlocked double C. Now, if you've ever seen a Chanel product, be it perfume, makeup, accessory, or clothing, you always see the interlocked double C. And Chanel thought that the two vertical intertwining semicircle of the Huawei new application was similar to that theirs, so they opposed Huawei's application. And like I've stated several in in all of my IP series, be it on Twitter or my podcast, that one of the process of registering a trademark is the opposition stage, and you can't do without that. I mean, that's one of the most important stage you need to pass before actually getting your certificate. In Nigeria, any person or third party can oppose a trademark application within 2 months from the date of when the adverts in the journal has been published, for the registration of a mark. Giving the registrar may give notice that anyone can come and oppose the trademark registration. Section 20 of the Trademark Act and Rule 48 of the Trademark Regulation explains or states what should be done. But I'm going to state or read what Rule 48 says. It said that provides that the person must include the reason why they are opposing the mark in question, which is what Chanel did in this case in the EU, because of the fact that IP is territorial in nature. So whatever you're doing has to be within the jurisdiction that you actually do your business in. So the process of opposing a mark in the EU is similar to what we do here in Nigeria. The only thing is the timeline. The timeline for opposing a mark in Nigeria is 2 months, whereas for the EU is 3 months. And according to a publication by Feingarn, opposition of an EU trademark at the EU Intellectual Property Office, the proprietor of the opposed EU mark will have to refile the mark in the UK, and this is because of post-Brexit. And once it's been published, it can be opposed based on prior UK marks. And if the opposer decides to oppose the refined UK mark, it will be 2 independent proceedings, one at the EU IPO and another at the UK IPO. However, because this case was pre-Brexit, opposition at the EU IPO, that's the European Union Intellectual Property Office, you will be required to file within 3 months following the publication of the EU trademark application and the EU trademark bulletin, and processed. It will be processed by the opposition division after checking the status of payment, that it was done in record time. The opposition division will examine whether the notice of opposition fulfills the basic requirements, and if it finds any deficiency that can be remedied, the opponent is required to do so. Once the phase has ended, the applicant for the EU mark will be advised of the notice of opposition, and a period of 2 months will be given to both of the parties to contact each other and try to resolve and come to a friendly settlement. And this process is known as the cooling off period, which is really interesting. I mean, give the parties the opportunity to have that conversation, like, okay, so your mark is similar to mine. What do you want to do? Are you going to cancel your registration, or what should we do? But yeah, I have talked about likelihood of confusion in a logo in the Apple and PI case last year. You can check out that podcast episode and the Twitter version as well. Remember I had said this case started in 2017. Now, in 2019, the EU IPO dismissed Chanel's objection that the two logos were not similar in any way and would not cause any confusion amongst consumers, because consumer is king. Because of this perception, this was what the US Patent and Trademark Office had decided in the Booking.com case. I also did a podcast version of that. And then I did a poll asking, do you think the Huawei logo looks similar to that of the Chanel? And 69% said no, it doesn't. 23% said taking a second look, while 8% said yes, it does. Seriously, guys, I don't think they look similar. But we move, man. Now, when doing a trademark registration, the IP attorney or agent is supposed to help the applicant determine if their mark, that's the mark they wish to register, meets the distinctiveness test. And in Nigeria, this can be found in Section 9 of the Nigerian Trademark Act. Also, Section 17 of the Act states that you can apply to get a preliminary advice on the distinctiveness of the mark from the registrar. Now, grounds for opposition in the EU: likelihood of confusion, which is what Chanel relied on. 2, unauthorized filing by an agent, where you did not authorize an agent to file a trademark application for you. 3, double identity. 4, reputation, especially if it will encroach on the goodwill of the earlier mark. 5, designation of origin, that is, trademark as an IP is considered to be a source identifier, and geographical indication, that's a sign used on products that have a specific geographical origin and possesses qualities of a reputation that are due to that origin. So designation of origin, where beneficiaries are under the EU legislation or member states, can oppose any registration. You can also check out my podcast episode with Mr. Sandemba, where we talked about geographical indication as a tool for boosting and exporting a country's product. Now, Shina wasn't happy with the decision of the EU IPO and then challenged the ruling at the EU General Court of Luxembourg. And earlier, sometime in April, the claim was dismissed by the judges, who gave the following reason: that the figurative mark at issue is not similar. The mark must be compared as applied for and registered, and there were visual differences between the two logos. Now, the Chanel logo is said to have more rounded curves, thicker lines, and horizontal orientation, while the Huawei mark is said to be vertical. And so the mark were considered to not be similar. And I did another post saying, can two marks be similar in nature? 50% said yes, then 3% said no, 70% said they just give like a smiley face. So is it possible for two marks to be similar? Yes, if you can show that there's no likelihood of confusion and it's not registered in the same class or line of business. There are two ways anyways, and no, if there's proof that there's evidence that is likely to cause confusion, then the two marks cannot exist, which is why people always sue for infringement. So it's a yes or no answer, but then the evidence is on you to prove. I'd also done a similar podcast on when two brands bear the same name or mark and what should be done. If there's a likelihood of confusion, then the two marks can't survive, they can't do business together. Now, the take home for SMEs in Nigeria, especially in light of the World IP Day theme for this year, which is IP and SMEs taking your ideas to the market, is IP is territorial in nature. Trademarks can be registered, but it has to be distinctive in line with Section 9 of the Nigerian Trademark Act. In Nigeria, we apply the first to file principle. If you are focused on brand identity, a trademark is the first form of IP protection you should consider and explore. Invest in your brand, as IP is a long-term goal for businesses. Your business name, logo, sign, symbol, anything that identifies your brand needs to be protected, especially in this digital era where it's easy for people to mass reproduce your work. Guide your product quality before taking it to the market. Register your IP before also taking it to the market. You can also generate extra revenue by commercializing your intellectual property while growing the business. Build your IP portfolio and have an IP firm manage it for you. In the event of an IP related dispute, you have two options: litigate or explore alternative dispute resolution mechanisms such as mediation, arbitration, negotiation, or a hybrid mechanism. In the event that you lose at the opposition stage in Nigeria, you can appeal to the court, and in this case, the Federal High Court, which has jurisdiction to hear IP related matters. See section 21 of the Trademark Act. Subsection 4 also provides that when you are on appeal, you can't add any extra ground for the appeal to be taken by the opponent or the registrar, except with the leave of court. Anyway, Chanel has one more shot at the EU Court of Justice, which is the highest in the country. So let's see how this case between Chanel and Huawei ends up. Prospective trademark owners should consider doing a thorough international search to avoid issues on similarities or likelihood of confusion amongst consumers. Consider registering your mark as a domain name, as trademark and domain name are related. Before you take your idea to the market, document your pre-market and pre-contract stage. And finally, guys, see IP as an investment and explore a multi-layered IP protection for your creation or invention. And so we've come to the end of today's episode. If you learned something and if you enjoyed this episode, please support my podcast. Please, guys, support my podcast so you keep seeing future episodes on all of the platforms. Subscribe. Favorite. Support. Share, like, guys. But yeah, if you did find this episode educative, give me a thumbs up, a like. If you also want to be featured as a guest, please send us an email to ipseriesinfo@gmail.com, or you can DM us on Twitter, ipseries1, Instagram, ip.series, LinkedIn, ipseries with Reader is spelled REEDAH. And yeah, until the next IP series episode, do have a fab week.